The next date is date versus Kinard. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
5 minutes, please.
Thank you. I'll make note of that. When you are at 1 minute left in your initial time, I'll let you know that. I will not give you a warning at the end of your rebuttal, so you're kind of on your own there. And counsel, again, I'll let you know a minute left in your time as well if we get to that point. The arguments are being recorded, so please make sure you introduce yourself when you come to the podium. Please stay behind the podium and speak loud enough so we can hear you. When obviously don't move, so we can record you. If you have to use the name of any child, minor, or victim in this matter, please use initials or some other designation rather than their full name. With that, the court is ready to brief and ready to proceed whenever you are.
Thank you, Your Honor. May it please the court. My name is Attorney Wesley Buchanan, and I have the privilege of representing DaCarrei Kinard, who is the appellant in this matter. As indicated, we'd like to reserve 5 minutes for rebuttal. At the outset, DaCarrei is going to note that this killing was justified partially. As indicated by the record, DaCarrei was indicted for murder, but the jury only found guilty of voluntary manslaughter. That's important to note, especially under the manifest weight designation when this court sits as the 13th juror in this case. The primary argument that DaCarrei has is that there were 32 videos by the decedent of typical road rage incidents that the decedent was involved in. As part of the record, on March 19th, 2024, DaCarrei, through counsel, filed a reverse motion in limine. It was titled a motion to admit evidence. So typically when someone files a motion to eliminate or trying to exclude or prevent the trial court or a party from doing something, in this case it was the opposite. Specifically, DaCarrei notes the State v. Barnes case and the footnote, which is applicable here, where the Ohio Supreme Court took no position on what we're talking about here. So, as far as the court is concerned, the trial court heard the motion in limine during the day of trial, which is prior to trial, and then overruled DaCarrei's motion and thus excluded those 32 videos from evidence. And that's very, very important here because the trier of fact, again, already found that the killing was partially justified. And so should the jury have found and had all the evidence that could have been admitted, then there's a good chance that DaCarrei could have been acquitted of all of the cases. In addition, as far as the Ohio Supreme Court is concerned, the State v. Barnes case, so it's relevant because of the second prong of self-defense. In this case, the first prong, the government conceded that the decedent was the initial aggressor, and that's in the record. And then finally, on the third prong,
If they're conceding that for 404B evidence, doesn't have to be a material and a dispute between the parties? And here, was there a dispute on who the initial aggressor was?
the government conceded that the decedent was the initial aggressor. The reason that the evidence should have come in, and the reason that typically this court would review an admission or exclusion of evidence under an abuse of discretion standard, which is, as this court knows, unreasonable, arbitrary, capricious. DaCarrei believes that this was an error of law, which means this court can review that decision de novo. And with that decision, because of the second prong, the specific incidents of the 32 videos that the decedent took can go to DaCarrei's state of mind, because one of the prongs for self-defense is that DaCarrei had to be in fear of great bodily and grievous harm or imminent death. And that's part of the standard that self-defense is. Those could have been relevant here, and that would have been up to the trier of fact, in this case the jury, to decide. However, again, the court did not commit those videos into evidence. And I think there was some dispute as to whether or not DaCarrei preserved this error for appeal, but DaCarrei did file through counsel a motion to admit this evidence. And so that's why it's important that he did preserve this error for appeal. In addition, as far as the self-defense claim, DaCarrei was, the jury was not instructed on self-defense on one of the counts. And this court in State v. Henley had said self-defense is self-defense. And it's very telling because in that State v. Henley, this court came up with a paradox that this is applicable here, is that, if you're going to allow somebody to use self-defense, then someone acting in self-defense should be able to do so without fear of incurring additional charges. Because if the defense applies, the defense applies. And that was specifically stated by this court in that case. And again, as far as the manifest weight challenge from this court, DaCarrei testified in his own defense. He took the stand in his own defense. He described the situation. The record is replete with what happened here. Very rarely do we have a situation where you've got a lot of evidence. Also, most of this evidence was on video as well. And involuntary manslaughter, that's what the jury came back with as guilt. That's what's important here. And that leads into the sentencing aspect of DaCarrei's assignments of error. Voluntary manslaughter requires sudden heat of passion or rage, whereas murder requires purposefully, knowingly in a felony murder case. This case, the jury acquitted on the felony murder, even though they found him guilty of the felonious assault. So that's very, very important for this court to note. The voluntary manslaughter, there is a knowingly standard within the voluntary manslaughter statute. However, the voluntary manslaughter statute truly focuses on the mitigation of the sudden fit of rage and passion. That's why it's a lesser included of murder. And so that additional element DaCarrei would submit means that as far as the consecutive sentencing for the specifications are not applicable here.
Has the Supreme Court said that it's a lesser included of murder?
Voluntary manslaughter? I believe the Supreme Court has. I don't have the case off the top of my head, but I believe that voluntary manslaughter is the lesser included of murder, and that's why it was instructed. The trial counsel made the strategic choice to have the jury instructed as such. Does that answer the court's question?
It does, thank you.
So as far as DaCarrei's assignments of error, one that does lead into the ineffective assistance would be that trial counsel did not ask for the self-defense instruction on one of the counts. The count that where I believe it was the weapons under disability, that DaCarrei was not permitted to have a firearm. However, again, safety handling would have permitted that instruction to go to the jury in this sense.
And I presume one of the issues didn't raise it, didn't object to not being included below, so that's why it's ineffective assistance?
Correct. Yeah, there was the discussion of the jury instructions with both trial counsels and with the government, and then there was no objection to the self-defense not being included into that specific
Would
count.
there be prejudice here because the self-defense was included in certain charges and the court did not, or the jury did not find self-defense in this manner? Why would they have found it on this additional charge that you'll point out? So where's the prejudice?
The prejudice is that the jury found this was partially justified, right? So the jury may have rejected self-defense, but they accepted voluntary manslaughter. So in essence, they're saying, yes, DaCarrei has a sudden fit of rage and passion in this killing. However, he was not able to have the ability to self-defense. I mean, that leads to almost mutually exclusive. Because if I'm acting in self-defense, I'm not under a passion or rage to make the killing. The voluntary manslaughter requires the passion and the sudden fit of rage. If I'm defending myself, I'm defending myself. And that goes to intent. That goes to the mens rea. That goes to the knowingly and purposely elements of the offense. In addition, it goes to DaCarrei's state of mind when he was under threat of grievous harm or death. Because subjectively, the jury sits in his shoes based upon all facts and evidence, and that's what the jury instructions indicate, is that you step into the person who's claiming self-defense's shoes. Also, now that the burden has shifted, because it used to be that DaCarrei would have the burden to show self-defense, now the government has to disprove self-defense. That's why it makes those videos relevant as well, because then this becomes situational to that issue of, is it self-defense or that sudden passion of a fit of rage? Because again, can you have two intents? Possibly, but if I'm defending myself from someone who's trying to kill me with a car on a freeway, does that lead to, by definition, that sudden fit of passion and rage? And DaCarrei would submit those are different. And that's why this is one of the situations where manifest weight, because DaCarrei understands that under a sufficiency analysis, this court has to take all the evidence in the light most favorable to the government and take all the inferences there so. So DaCarrei understands that. However, under the manifest weight standard, where this court sits as the 13th juror, DaCarrei would submit that a lot of these inferences, while the jury is free to believe all, some, or none of the testimony, would lead to this being the exceptional case where this court should reverse and order a new trial, and then include the evidence that had been excluded. And that's why it leads to the court's question of self-defense was included on some counts, but not other counts. And that's where the prejudice is, because the jury did convict of a lesser included.
1 minute, counsel.
Thank you, judges, and if the court does not have any other questions.
Counsel, I do have a question. The use of this term that you are saying partially justified, I'm curious about that. Have you cited the court to law that uses that term?
I have made those inferences because voluntary manslaughter is a lesser included of murder. Under Blockberger, the test is if you were charged with murder and you are convicted of voluntary manslaughter, by definition, you're found not guilty of murder. And in this case, the jury came back with a not guilty of murder. So in essence, it was not purposefully and knowingly killing. It was a killing based upon voluntary manslaughter, and that statute, again, requires a sudden fit of passion or rage.
So you do not believe that the mens rea for the statute is knowingly?
The mens rea for knowingly is voluntary manslaughter. Yes, it is knowingly. However, there's also knowingly in fat of rage and under heat of passion. And so does that help answer the court's question?
Sure, thank you.
Thank you. If the court doesn't have any other questions, I'd like to reserve the balance of the time for rebuttal.
Thank you.
Thank you.
May it please the court, Ellen D. Martina, on behalf of the state of Ohio, DaCarrei, we are asking that this court affirm Mr. Kinard's convictions as well as his sentence. With regard to the initial statement made by opposing counsel that this killing was partially justified in some way based on the jury's finding of voluntary manslaughter instead of murder, this state will respectfully submit that that is not based on case law, that those inferences are not logical. The case law that talks about manslaughter and murder refers to it in State v. Rhodes as a way to mitigate culpability, not as a lesser included. Voluntary manslaughter has different elements than murder under 290302A or B. The state would further submit that self-defense and manslaughter are inconsistent. In this particular case, Mr. Kinard got the benefit of an instruction on an inferior offense of voluntary manslaughter and an instruction on self-defense. With respect to the murder charges and the felonious assault, the parties all agreed that the charge of discharging a firearm in a prohibited place, which would be across the roadway, that there is no self-defense to that. You're not defending yourself. Those elements do not fit that particular offense. Even if there was some error in the judge, the prosecutor, and the defense attorney all coming to that conclusion, and there's no case law cited here that self-defense applies to that statute. The jury in this case clearly found that Mr. Kinard did not act in self-defense because they did not acquit him of all the charges. They found him guilty of an offense that has lesser culpability. And the reason why that has lesser culpability is because of the heat of passion, the sudden fit of rage. But the element is still knowingly. That is still a required element, that he acted based on some serious provocation brought on by the victim that would cause a disbelief that a reasonable person would be incited to use deadly force. I don't recall anywhere in the testimony with regard to self-defense where the state conceded that the victim in this case was the primary aggressor. Certainly there was evidence that the decedent was driving the Mazda and that he brake checked the Camaro that Mr. Kinard was driving multiple times. But the evidence also showed that Mr. Kinard then passed the vehicles on the right, went into the berm so he could speed back up, catch up to the Mazda, and then shoot the driver of the Mazda, causing the car to crash into the berm. So the state would dispute that that was conceded anywhere in the record. I didn't hear any citations, anything in the transcript, and I do not recall that being conceded. And I would represent that while the driver of the Mazda performed that brake check, which I think everyone in this room knows what a brake check is and has probably experienced it in some way, shape, or form in the course of being a driver or passenger on the road, no one is saying that that would give rise to somebody saying that you could use deadly force. What Mr. Kinard tries to say is that at some point he thought he saw a black object, which he doesn't say was a gun, but he believed it was a gun, and that's why he fired. But with respect to that first assignment of error, when it goes to the weight, this is not a partial justification when a jury finds a defendant guilty of voluntary manslaughter instead of murder. That is not a form of self-defense. It is not saying that he was partially justified. It is simply saying that he acted in a sudden fit of rage that was brought on or occasioned by some act of the victim, and that he believed, that a normal person's reaction to that would be to use deadly force. The self-defense elements are different from that. You have to believe that you are in imminent danger of death or great bodily harm, which is distinctly a different set of facts than what is required for voluntary manslaughter. So that first assignment of error is based on, some attempt to cobble different cases together and come up with a conclusion that is not supported by case law and truly is contrary to case law, which would say that the Supreme Court has said that voluntary manslaughter can mitigate culpability, not that it's a lesser included, and not that it's a form of self-defense. With regard to the video and the videos of road rage, the Supreme Court looked at a case with regard to determining, for purposes of self-defense, if the victim was the primary aggressor. The court did say for other purposes of self-defense, we're kind of staying silent on that issue. But the holding in State versus Barnes was that you cannot use specific acts by the victim. This court, the trial court, said you can use an argument about propensity, but you can't use specific acts by the victim on a different day to show that on this day, that same victim was the primary aggressor. And that's consistent with what we do in all types of cases, whether it's talking about sexual conduct in a sex case. We're not going to say, oh, on some other days they act this way, but on this particular day, this is what it means. And the defendant did not articulate in the trial court or here on appeal what purpose under 404B they would be using those prior videos, or what element of self-defense they're trying to then prove here today through those prior videos. It doesn't fit, and it would be consistent with the Supreme Court's holding in State versus Barnes to exclude a victim's prior videos, specifically in this case with regard to the road rage, to show that on this particular date, this victim was the primary aggressor because in the past they had engaged in road rage. That is contrary to what the law would require, and this court should affirm the trial court's decision with regard to that assignment of error. Therefore, the trial court was correct in excluding that evidence. With regard to the argument that because of the jury instruction not talking about negligent homicide, this court should find that what the trial court actually found was negligent homicide is not consistent with the Supreme Court's holding in State versus Coss or the 9th District's holding in State versus Brown, because the Ohio Supreme Court and the 9th District has said that negligent homicide is not a lesser included offense of murder. Therefore, that argument in the third assignment of error should be overruled. With regard to the argument about ineffective assistance of counsel, counsel is solely citing 229-23-162A3 with regard to a request for self-defense, the discharge of a firearm, and the state would submit, or there's no case law to support that charge would be something that you get a self-defense argument or an instruction on, and even if it was in this case, it would have not affected the outcome of the case because the jury did not find that he acted in self-defense. Again, going to that manslaughter is not a justification of murder, it's just a lesser culpability. And with regard to the sentence, the Ohio Supreme Court has said in Bolar that it doesn't matter if the underlying charges have merged. The statutory requirement for the if you have two mandatory gun specifications, they are required to run consecutively under 14B1G. In this particular case, that is what the court did. They found the two mandatory firearm specifications and ran them consecutively, which is consistent with the Ohio Revised Code as well as the Ohio Supreme Court's decisions in State versus Betty and State versus Bolar. And it does
those cases apply though? The gun spec for drive-by is not in 29, 29, 14A, it's in 29, 29, 14 C, I believe. So it is just a section.
It is
Do those cases only apply to the A section cases, or the cases you decided to apply to any gun spec throughout the statute?
They would apply to any gun spec, and the courts were specifically looking in those cases with regard to, is it 2 or is it, 3 mandatory? How many can you stack consecutively? The court came down with it's 2, and then you would look at the rest. So it does not matter that the drive-by specification was in another section, consistent with the Ohio Revised Code. There's been no invitation particularly made here on why the court should distinguish State versus Betty or State versus Bolar from that case of line of cases.
Bolar, those cases just based upon the statutory language, correct?
Correct.
We'd have to look at the language and see if it applies to saying here that it didn't apply.
Correct. And the state would argue that there is no distinction to be made with regard to the specification. Are there any questions? If there are no questions, then I would rest on a brief and I would ask that this court affirm Mr. Kinard's convictions and his sentence.
Thank you. You have your full time for rebuttal.
Thank you, Your Honors. May it please the court. DaCarrei would submit that, again, this is an exceptional case where this court should reverse the trial court and find an error that would permit DaCarrei to have a new trial with the evidence to be included. As far as the articulation, the trial counsel did in their motion articulate when it was filed with the court. And as far as that motion to eliminate, I believe in the transcripts very early on when they were discussing the admission or the non-admission of these videos, the prosecutor may have stipulated that decedent was the initial aggressor. So at least those citations for that. So as far as DaCarrei is concerned, he, again, understands that this is a serious case and whatnot. However, because of what the evidence showed, DaCarrei would believe that this is against the manifest weight. The trial court did improperly exclude evidence that should have been included for the trier of fact to include. And with that, if the panel does not have any other questions, DaCarrei thanks the panel for its time and appreciates the reversal. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. When that decision is released, we'll mail it to you by the court and also available on the Ohio Supreme Court website. With that, I'd like to thank both of you for your presentations on behalf of the court this morning.